Welcome to the Republican Professor. I'm your host, Dr. Lucas J. Mather. Today is Monday, 29 June, 2026 years after Jesus. And we started last year honoring this guy, Richard A. Epstein. I love this guy. Talking about property rights and constitutional law, which is a fitting topic for the week because we are coming up on the day of the 250th anniversary of the United States of America. And this is an analysis, as you know. We're on episode 12 of this series that we started last year, honoring the 40th anniversary of takings, private property, and the power of eminent domain by Richard A. Epstein, Harvard University Press. At the time it was published in 1985, Richard A. Epstein is or was James Parker Hall Professor of Law at the University of Chicago. Now, we ended our time last month in May 22nd, right at the cusp of chapter 7, which is called Rights of Disposition and Contract. It is in the section called Takings Prima Facie, and we're going to do a fair use of this material and make a transformative reading. We'd like to thank Richard A. Epstein for writing it, and we'd like to thank Harvard University Press for making it available. I can't believe those words came out of my mouth, but yeah, Harvard, good job. Um, let's seriously give Richard A. Epstein some street cred. I had his co-host John Yoo on the podcast back in 2022. John Yoo is a professor at the University of Berkeley School of Law, and I think he's also a fellow at Hoover, at Stanford, and at the Civitas Institute at the University of All My Exes Live in Texas, Austin. But John does a podcast with Richard Epstein called Law Talk, and that's an excellent podcast. I've been listening to it for years. It's usually about an hour long, and they cover, I think it's like once a month. And then Richard does one, I think it might be weekly, called The Libertarian. It's about 20 minutes long, and that's very good as well. Well, let's get into this chapter 7 discussion, Rights of Disposition and Contract. The first subtitle is Interference with Prospective Advantage. Interference with Prospective Advantage, page 74. Let's dive in and take a look at this. This chapter completes the examination of partial takings by looking at cases where the incidents of possession and use are left untouched, while the incident of disposition is taken or destroyed in whole or in part. So starts Richard Epstein in chapter 7. The parity between the state and the private defendant can be maintained as before if the plaintiff owns certain property, then it is wrongful for any private defendant, by use of force or threat thereof, to hinder, block, or condition its transfer to a third party, because that constitutes an interference with prospective advantage long recognized as a private tort. Taking a look at the footnote, we're going to skip the footnote 1. The right of disposition is a property right in the same degree and manner as the right to exclusive possession. What a plaintiff demands is non-interference by the rest of the world in his dealings with any third party X. This claim in no way depends upon a contract with X. At stake is the right to contract with X, which is good against the world. Nor is the owner's claim a mere tort right, for as the earlier discussion of conversion and destruction shows, torts themselves are subclass of takings. That's very interesting. Torts themselves are a subclass of takings. Oh, yeah. Well, I've obviously thought about that before because my notes are right there and I'm thinking about it again. Yeah, I have it underlined actually. But, sometimes I read it before and I don't remember reading it. But it's almost like I read it for the first time just now. I read this back, well, last April, April 2025, the day after Easter. Okay. Now, by the major Lockean premise, the state stands in no better position. This is excellent right here. Right here. This is excellent. He treats the state just like he would a private actor here. Let the state impose restrictions or conditions upon the right of disposition. Let it block or hinder sale or lease or mortgage. Then it too has taken property for which compensation is prima facie required. Take a look at footnote 2. Uh, that's actually a decent one, but we're going to skip it. The nature, we're on page 75 at the top. The nature of the restriction and the conditions associated with it may determine the appropriate level of damages, and the restriction in question may perhaps be justified. But prima facie, the situation is indistinguishable from one in which the affected property has been taken outright and returned with subject. Excuse me. Ooh, this is pretty bright. Um, okay, the nature of restriction and the conditions associated with it may determine the appropriate level of damages, and the restriction in question may perhaps be justified. But prima facie, the situation is indistinguishable from one in which the affected property has been taken outright and returned subject to limitations upon its future disposition. A complete taking with partial, that is, a complete taking with partial compensation. The analysis of the right of disposition thus far parallels that of possession and use. In one important respect, however, alienation differs from those incidents. Because the interest in alienation is relational, it is necessary to examine how government limitations upon it affect both potential sellers, that is, present owners, and potential purchasers of the property, while recognizing throughout that the government's rights can never rise above those of private individuals it represents. Now, that's a key point right there. Happy 250th anniversary of the United States of America. That is a key point. That's a key point. Yeah. The government's rights can never rise above those of the individuals it represents. Wow. Any restriction that in form restricts only disposition by the owner perforce limits the rights of others to acquire property in exchange for their cash, property, and perhaps labor. The takings clause reaches both the buyer and the seller, not just the seller. This is not to say that the purchaser's position is identical to the seller's, for constitutional differences do emerge on a separate issue of implicit in-kind compensation. In sharp contrast to this basic theory, Richard says, the judicial response to the right of disposition is marked by a general hostility. All right. He said it. He said it. See, this is the reason for his book. Why would a professor of law be wading in there and saying what he thinks? Well, because he's saying the reason we need to study this is because the government screws it up and the voters screw it up. And which part of the government? Well, the part of the government he just mentioned was the courts, the judiciary screws this up. And you can ultimately blame that to some extent on voters because voters really should know better, but they don't. Maybe you blame it on the educational system. I don't know. But yeah, so in sharp contrast to this basic theory, that is, that the government should be treated more or less identically to a private actor, not more special, not more special. The judicial response to the right of disposition is marked by a general hostility, tempered only by occasional protection of the independent status of the right of disposition, usually the seller's side. This chapter considers three kinds of cases. The first and easiest involves government restriction upon the power to sell private property. The second involves the condemnation of leasehold interests, which the tenant holds with the expectation but not the right of renewal. The third involves the treatment of goodwill in cases where the aggrieved owner is not dispossessed. Thereafter, I discuss the interference of rights under existing contracts as distinguished from the interference with prospective advantage. We're on page 76 at the top. Are you interested in this? Do you like this? Again, we're interested. We're taking a look at having a discussion of takings, private property, and the power of eminent domain by Richard A. Epstein. Go out and get your copy today. Get it, put it on your bookshelf, impress your friends and your enemies. Thank you, Richard, for writing this. Prohibitions on the right to sell. This is the first class he was talking about. In Andrus versus Allard, the appellees alleged the regulations under the Eagle Protection Act, insofar as they prohibited the sale of any objects which contained eagle feathers, even those from birds which were legally acquired before the government prohibition. Wow, that's interesting. Do you guys know that having an eagle feather is a felony? I mean, if you're not an Indian. If you're an Indian, it's different. If you touch one, if you touch an eagle feather, it's a felony. Good luck proving that. But you know, I'm sure there's cases. Um, so the regulations did not prohibit all forms of disposition of the property in question, as it is crucial that appellees retain the rights to possess and transport their property and to denote or devise the protected birds. Uh, on its facts, the case is a simple one. The right of sale is part, and perhaps the most valuable part, of the right of disposition. Remember, we're talking about eagle feathers, okay? You find one on the ground and then you want to sell it, right? Okay. Prohibitions on the right to sell. Merely having it, merely touching it is a criminal offense. Okay, so that would be a prohibition on the right to sell it because to sell it, presumably you have to touch it. You have to have it. You have to possess it. So how can you sell it if that's a crime? A preconditioning of selling it is a crime. Um, so the loss of this right is not merely a diminution in value, but it is a deprivation of a property right, a partial taking for which compensation is prima facie required. Oh man, Richard, getting into eagle feathers. Um, to deflect this simple conclusion, the Supreme Court resorted to its usual arguments. It noted first that, quote, the denial of one traditional property right does not always amount to taking. At least where one owner possesses a full bundle of property rights, the destruction of one strand of the bundle is not a taking because the aggregate must be viewed in its entirety, unquote. uh, yeah, okay. Interest balancing. But this is inconsistent with the court's oft-stated and correct premise that partial takings are covered by the eminent domain clause. There's the textualism coming in to save the day. The statement also looks to what the owner has retained when the question is always what he has lost. Retention of certain or even all beneficial uses are material only to finding the right measure of damages once the taking is established. Matters are not advanced by urging that compensation should be denied because the estimation of lost profits is clouded in uncertainty. See, Richard's not going to let them get off the hook that easily. That's why I love this guy. The best estimate of value is surely not zero, and the loss of market value is no more difficult to estimate here than are lost profits in the wide range of contract and tort cases at common law, in which they are routinely allowed. The government cannot prevail simply by denying that the taking has occurred. Man, put that on a coffee mug, put that on a calendar, put that on a t-shirt. That's July in Natural Right magazine. The government cannot prevail simply by denying that the taking has occurred. Whatever difficulties the case presents are with the police power. Yes. Since the prohibition on the sale of eagle feathers presently owned might be intended to protect feathers on eagles in the public domain, for example, by licensing eagle feathers that are already in private hands. All right. So we got the eagle feather case. I like that case. Leasehold renewals, page 77 at the top. This is the second class of cases that he's going to discuss. I liked the eagle feather one. Yeah. Okay, let's take a look at this. The question of disposition also arises with leasehold renewals. In the simplest case, the tenant has the option to renew from his landlord upon stated terms. As the option is at least a contract right, if not an equitable interest in land enforceable by specific performance, the courts have not had any difficulty in awarding compensation to the tenant for its loss when land is taken outright. The more difficult and interesting question arises when there is only the expectation of renewal, usually supported by past practice, built into the value of the tenant's lease. An assignee may well pay a price that reflects the value and probability of renewal at the end of the term. Indeed, the expectation may in fact have a substantial value to the tenant, even if the landlord will renew only to this tenant. The value in use can be positive, even if the value in exchange is zero. The dominant judicial rule, however, is that the tenant's expectation of renewal is not a form of private property that can be taken only with compensation. See, speaking of eagle feathers, Richard has eagle eyes, man. He spots this stuff a mile away, a mile away. He's like, yeah. And look at, he's pretty hard on the judiciary. I like it. I love it. You don't let judges off the hook, man. You don't let them off the hook, dude. The dominant judicial rule, see, that's a criticism he's preparing to criticize the judges. The dominant judicial rule, however, is that the tenant's expectation of renewal is not a form of property, private property that can be taken only with compensation. The most oft quoted statement of the rule is that of Holmes in Emery versus Boston Terminal Company, and that's Oliver Wendell Holmes, 1901. Now, here's a block quote. Changeable intentions are not an interest in land, and although no doubt such intentions may have added practically to the value of the petitioner's holding, they could not be taken into account in determining what the respondent should pay. They added nothing to the tenant's legal rights, and legal rights are all that must be paid for. Even if such intentions added to the saleable value of the lease, The addition would represent a speculation on a chance, not a legal right. I think the air conditioner just went on. And if that's the case, I need to close a window. I didn't realize it was that warm. I have the air conditioner up pretty hot. Okay, so 1 second. I'll be right back. Yeah, I do want to go through Oliver Wendell Holmes' uh, book on the common law because I think it's really interesting and it's decent. Um, I don't really like him. He got the right answer. He got the wrong answer in Lochner versus New York. Um, he got the wrong answer in a lot of things, you know. But we've covered Lochner on the podcast, so I wanted to mention Lochner on that. Okay, now uh, the block quote is finished now, and that's from 1901. Now, the insistence that only legal rights must be paid for is surely correct. Don't call me Shirley, Richard. But they can be found on both sides of the transaction. A third party who takes the land or by lesser means blocks the renewal commits a tort against both the landlord and the tenant. This action prejudices the rights of the tenant to acquire as well as the rights of the landlord to dispose. It is therefore actionable at the instance of both. The expectation of a successful renewal works to the benefit of both lessor and lessee, and therefore the value of their joint right to renew should be reflected in any enhanced compensation award to be divided between landlord and tenant in accordance with their interest. The problem assumes a new dimension, page 78 at the top, when the tenant owns certain property, for example, improvements or trade fixtures, which, when not taken by the government, have no value except in use on the condemned land. Now, that's a very interesting. Yeah, that's very interesting right there. Condemned land. Okay. In Alamoda Farmers Elevator and Warehouse Company versus United States, and that would be 1973. The tenant plaintiff had, for about 48 years, occupied land under a series of leases obtained from the landlord, the operator of the adjacent railroad. When the government condemned the land, the current lease had 7.5 years to run, but contained no option for further renewals. While in possession, the tenant had constructed upon the real estate certain improvements whose expected useful life was far in excess of 7.5 years. Owing to their customized nature, the improvements had little salvage value separate from the premises. This is a pickle. The government conceded that compensation was owing for the leasehold, including the sale, including the value of the improvements for the remaining years of the lease. The Supreme Court, despite its general rule of no compensation for any additional value based on the expectation that the lease might be renewed, included in the award the market value of the renewal rights in setting the compensation payable for the leasehold interest. The court then sought to distinguish Almota from the earlier case of United States versus Petty Motor Company, which was 1946, which, on the strength of Emery, had denied compensation for the expectation of renewal of the ordinary commercial lease. It noted that in Petty Motor, quote, the court was not dealing with a fair market value of improvements. Unlike Petty Motor, there is no question here of creating a legally cognizable value where none existed, or of compensating a mere incorporeal expectation. The petitioner here has constructed the improvements and seeks only their fair market value. Unquote. This purported distinction will not do. Now, this is very good. Now, this is how you proceed. Because um, you of course want to celebrate when the court gets it right, but sometimes they mess it up a little bit even when they're getting it right. And the messing up oftentimes comes when they're distinguishing precedent from the present case in order to say something they think is new or interesting or right, and they can't figure out how to do it except for by these distinguishing kind of tricks and analysis. But then what happens when you get the distinction wrong? That's what Richard is saying here. Now, this purported distinction will not do, as it misperceives the law of future interests. Conceptually, the improvements under the lease can be divided into two separate assets. The term of years owned by the tenant is distinct from the reversion in the same thing owned by the landlord, even if all the costs of erecting the improvement were borne solely by the tenant. Compensation, page 79 at the top, compensation to the tenant can never be for an interest owned by the landlord. The tenant cannot be compensated, therefore, for the landlord's reversion in the improvement, even if depreciable, any more than for the landlord's reversion in the land. The tenant can be paid only for the expectation of renewal in the improvements. The very ground earlier rejected in Emery and Petty Motor. The valuable and customized improvements are, along with the prior course of dealing, only evidence that the renewal would very likely have taken place, a point of great importance, but only in the valuation of the plaintiff's rights. The compensation tendered does not depend upon the tenant's right of being in possession of the property, but upon the independent right of disposition. Suppose that just before the initiation of condemnation proceedings, the plaintiff had constructed $100,000 worth of customized equipment to be installed on the condemned land. So we're doing easy numbers, right? Easy numbers, 100,000. Let's check it out. On the analysis given in Almoda, its value is non-compensable, even for the duration of the lease, because the improvement in question is not yet attached to the land. But that result is indefensible. This is what, see, look, listen to Richard, man. He is not giving up. He's like a bulldog. That result is indefensible. True, the case is complicated because the available uses left open to the tenant are in principle greater than those that remain after the machinery is annexed. Yeah. Okay. The case is complicated because the available uses left open to the tenant are in principle greater than those that remain after the machinery is annexed to the real estate. Yet here, the customized nature of the equipment may give it a salvage value or next best use of, say, 15,000. Easy numbers, okay, 15%. To take into account the unlikely possibility of non-renewal at the expiration of term, some portion of the 85,000 should not be recovered, but it is wholly improper for the tenant to bear the full loss. Although the government has taken only one limited incident out of the plaintiff's bag of ownership, it has taken I keep saying that, the government taken, has, this is Richard's whole freaking point here, man, in prima facie takings prima facie. The government has taken, although the government has taken only one limited incident out of the plaintiff's bag of ownership, it has taken the one incident that matters. It has taken the one incident that matters. The case against the government remains one of interference with prospective advantage, whether or not annexation has taken place. The takings language, see, here we go, back to textualism. The text of the Constitution controls. Look at the text. Look at what it says. The language, the takings language of the eminent domain clause reaches this transaction, even if the government insists that the owner remain or allows him to remain in possession of his customized equipment. We can go further. Even if the customized machinery was made by a party never in possession, the same result should apply. The owner of the machinery takes by agreement the risk that the landowner will not extend the favorable lease, but he does not assume the risk of interference by an external force in an advantageous relationship that he wishes to establish. See, the government really screws things up here. You got to be really careful with government actors and with the judiciary, which is part of the government here, after all. Um, yeah, the owner of the machinery takes by agreement the risk that the landowner will not extend the favorable lease, but he does not assume the risk of interference by an external force, that would be the government, in an advantageous relationship that he wishes to establish. Again, the award will be reduced to reflect the greater risk of contracting failure and the larger set of possibilities available for mitigating for mitigation. But the very fact that one can speak of ways to reduce the compensation award indicates why it is required in principle. In all instances, interference with prospective advantage by the use of force is as actionable against the government as it is against all private parties. Love it. Love it, Richard. Happy 250th anniversary of the United States of America. Nice job, Richard. Okay. Now, we've got the issue of goodwill. Let's see how long this goes. Um, Goodwill is a longer one, and I think we're going to stop there. It's going to be a shorter episode. We went to page 80 from page 74, and let's go ahead and make a note there. It is, after all, my Sabbath, and I'm just doing this to relax, man. I love this stuff. I love Richard, and I don't want to make it feel too much like work. Sometimes doing this is kind of fun. So this is episode 12, and it's Monday, 29 June, 2026 years after Jesus. We went from page 74 to page 80. That's not too bad. So we covered two of the three types of cases there regarding the eminent domain clause, takings prima facie, the rights of disposition and contract. TRP episode 12, 29 June 2026 years after Jesus. Well, thanks for joining me on The Republican Professor. I've been your host, Dr. Lucas J. Mather. I've enjoyed this time with you and with Richard A. Epstein's Takings, Private Property and the Power of Eminent Domain, published by Harvard University Press. 41 years ago it was published. Last year we started celebrating the 40th anniversary of this book. Go out and get your copy today of Takings, Private Property and the Power of Eminent Domain. I would also say that while you're on Harvard University Press's site, you should check out any books that are written by Philip Hamburger. Philip Hamburger, check him out. Love the guy. He came on the podcast, Columbia University, professor of law. Let's have a chaplain's corner. Lord, thank you for the ability to have private property. Lord, we thank you for people like Richard Epstein who have articulated the, some really valuable things in our constitutional history to protect private property. And we know that you, Lord, value private property, because how else will we understand the Ten Commandments? The issues in the prophets about injustice, Lord. The Ten Commandments: do not steal. Do not even think about it. Don't covet. And how could that not imply private property? How could that not be about your concern about injustice? Sexual immorality, of course, idolatry, but injustice is always there, and it always involves the treatment of people, which involves property. Thank you, Lord, for Richard. We ask that you'd bless him, and Lord, may he come to know you if he doesn't already. In Jesus' name, amen. Okay, we're going to get a psalm in, and we're going to do a Streams in the Desert. Okay, so continuing with our chaplain's corner here, we have Psalm 142 in the King James Version. I cried unto the Lord with my voice. With my voice unto the Lord did I make my supplication. I poured out my complaint before him. I shewed before him my trouble. When my spirit was overwhelmed within me, when thou knewest my path, in the way wherein I walked, have they privily laid a snare for me. Verse 4, Psalm 142, King James Version. I looked on my right hand and beheld, but there was no man that would know me. Refuge failed me. No man cared for my soul. I cried unto thee, O Lord. I said, Thou art my refuge and my portion in the land of the living. Attend unto my cry, for I am brought very low. Deliver me from my persecutors, for they are stronger than I. Bring my soul out of prison, that I may praise thy name. The righteous shall encompass me about, for thou shalt deal bountifully with me. That's verse 7, Psalm 142. We'll do Psalm 7. Verse 7 again. Bring my soul out of prison, that I may praise thy name. The righteous shall compass me about, for thou shalt deal bountifully with me. A moment of reflection, Psalm 142, King James Version. Now we have a reading from Streams in the Desert, January 31st. We're just going through this. We started going through this when Charlie Kirk was murdered, right around that same week. I think it was actually the day before we started this. He giveth quietness, Job 34:29. Quietness amid the dash of the storm. We sail the lake with him still, and we reach its middle waters. Far from land, under midnight skies, suddenly a great storm sweeps down. Earth and hell seem arrayed against us, and each billow threatens to overwhelm. Then he arises from his sleep, and he rebukes the winds and the waves. His hand waves benediction and repose over the rage of the tempestuous elements. His voice is heard above the scream of the wind and the cordage and the conflict of the billows. Peace, be still. Can you not hear it? And there is instantly a great calm. He giveth quietness. Quietness amid the loss of inward consolations. He sometimes withdraws these because we make too much of them. We are tempted to look at our joy, our ecstasies, our transports, our visions with too great complacency. Then love for love's sake withdraws them. But by his grace, he leads us to distinguish between them and himself. He draws nigh and whispers the assurance of his presence. Thus, an infinite calm comes to keep our heart and mind. He give, he giveth quietness. He giveth quietness, O elder brother, whose homeless feet have pressed our path of pain, whose hands have borne the burden of our sorrow, that in our losses we might find our gain. Of all thy gifts and infinite consolings, I ask but this in every troubled hour, to hear thy voice through all the tumult stealing, and rest serene beneath its tranquil power. Cares cannot fret me if my soul be dwelling in the air, in the still air of my faith's untroubled day. Grief cannot shake me if I walk beside thee, my hand in thine along the darkening way. Content to know there comes a radiant morning when from all shadows I shall find release, serene to wait the rapture of its dawning. Who can make trouble when thou sendest peace? January 31st, Streams in the Desert non-woke edition. I love this edition. A moment of reflection. You see something cool? When I bought this book, this is, published a long time ago. This is a 1925 edition, um, non-woke, Feliz Station, Los Angeles, California. There was this in it. It's a um, it's a promissory note for $20, and it's dated February 1st, 1952. Can you see that? This was in the book. Pretty cool, huh? It says paid, and it's initialed, and then there's a signature, and then there's some markings on the back in looks like stuff that was bought maybe on a tab or credit or something. I don't know, but so I keep this in here. Um, on acid free. This is acid free archival um, stuff that archivists use so that it doesn't fade and it lasts. Well, that was Streams in the Desert, January 31st, and Psalm 142, King James Version. God bless you guys. Thanks for joining me on the Republican Professor podcast discussing takings, private property, and the power of eminent domain by Richard A. Epstein, Harvard University Press. Go out and get your copy today. And happy 250th anniversary of the United States of America. God bless you guys. Take care. We'll see you next time.